Welcome to the OFCCP Construction Basics Series. It is our great honor at the Washington State Construction Center of Excellence to host this series in partnership with the U.S. Department of Labor's Office of Federal Contract Compliance Programs. I'm Christina Rupp, Director of the CCE. The CCE is the convening resource hub for Washington's construction industry, fostering partnerships between businesses, labor, government, and education systems. The CCE focuses on enhancing workforce development, removing apprenticeship and skilled trades entry barriers, and preparing a strong, knowledgeable, diverse workforce. The CCE supports the state community and technical college system and offers resources and training statewide, contributing significantly to the industry's growth and development. To learn more about us and all the services we offer, please visit our website, www.constructioncoe.com. It is my pleasure to introduce today's representatives from the U.S. Department of Labor. From the Office of Federal Contract Compliance Programs, we have Edward Cunningham, Compliance Specialist, and from the Wage and Hour Division, Stephen Yim, Community Outreach and Resource Planning Specialist. Thank you, Edward and Stephen, for joining us today. The information you're providing is extremely valuable for construction industry attendees nationwide. Ed, did you want to introduce yourself?
Yes, thank you. Thank you very much. My name is Edward Cunningham. I work for the Pacific Region Outreach Division of OFCCP, and I thank you for being here.
Hi, good afternoon, everyone. My name is Stephen Yim. I am the Community Outreach and Resource Planning Specialist for the Wage and Hour Division. I am based physically in the Seattle District Office. Happy to be here.
Wonderful, Stephen. And Edward, were you going to say anything about OFCCP to start off the process, or did you want Stephen to go ahead and begin his presentation?
I can go ahead and talk about OFCCP. OFCCP is a civil rights organization within the federal government. We have our jurisdiction over federal contractors and subcontractors doing business with the government. We have three parts of the OFCCP. We have enforcement side, we have investigative side, and we have the outreach side. The audit side is that we do audits on supply and service contractors and also construction contractors doing business with the government. Then we do investigations based upon complaints received. And then we have the compliance side where we get voluntary compliance through education and information sharing as we're doing here today. The Pacific region has district offices in Seattle, Washington, San Diego, LA, Orange County, San Jose, San Francisco, and Oregon. And there's compliance officers available to address any questions or concerns you have. Real quick, the regulations that we enforce are going to be Executive Order 11246. And Section 503 of the Rehabilitation Act and VEVRA. With those three programs covers a wide selection of protected classes and how we conduct audits on the contractors support the laws. I was going to talk about a little bit about the prohibiting pay secrecy, but am I covering that afterwards, Stephen, or first? Before Stephen?
Yeah, feel free to go ahead and go first, Ed.
Oh, okay. So hold on a second. One second. Okay. Is the screen showing with the OFCCP? Okay. So basically, like I said, my name is Edward Cunningham. I work for OFCCP. We're going to briefly talk about the prohibiting pay secrecy policies. And hold on, let me get back to the next one here. On April 8th, 2014, Executive Order 13665 was signed into prohibiting federal contractors from discriminating against workers who discuss, disclose, or inquire about compensation information. The regulations implementing the executive order became effective January 11th, 2016. Our objective today is to review the basics of Executive Order 13665 and provide a number of scenarios to help explain when employees would be protected in discussing, disclosing, or inquiring about compensation information, and when employees are not protected. We will also quickly highlight how OFCCP investigates the requirements. While we may not address every question that you have today, OFCCP website has FAQs, a fact sheet, and other helpful resources which may address your questions. A slide at the end of this presentation will include those websites for your information purposes. Executive Order 13665 added a prohibition to the list of protected bases in Executive Order 11246, which covers race, color, religion, sex, sexual orientation, gender identity, and national origin. In addition to those groups, covered federal contractors and subcontractors are prohibited from discriminating against employees and applicants because they discuss, inquire about, or disclose their own compensation or the compensation of others. The basic protections afforded by Executive Order 11246, as amended, apply to applicants and employees of federal contractors and subcontractors, and federally assisted construction contractors and subcontractors who hold over $10,000 in government contracts in a one-year revolving period. Contractors who have entered into or modified contracts or subcontracts since January 11, 2016 are required to comply with the pay transparency provisions. There may be many reasons for amending the Executive Order 11246 with provisions on pay secrecy. Despite the existence of laws protecting workers from gender-based compensation discrimination, a pay gap between men and women persists. In the first quarter of 2024, a wage data from the Bureau of Labor Statistics showed that the median unusual weekly earnings of a full-time wage and salary worker showed that women earned 83.2% of what men earn. Pay disparities also exist by race and ethnicity, with white workers earning 76.8% of the highest paid, while blacks earn 60.3% and Hispanics earn 58.4% of what Asian workers made, which was 76.6% also. Among the possible contributing factors to ensuring pay gap is the prevalence of worker prohibited on discussing compensation. By prohibiting discrimination against workers who discuss, inquire about, or disclose compensation, the pay transparency regulations will help prevent workers from being disciplined or fired for trying to learn if they're victims of compensation discrimination. These regulations, along with Section 7 and 8 of the National Labor Relations Act, prohibit covered employees from discriminating against employees, job applicants who discuss or disclose their own compensation or that of others. However, the pay transparency regulations extend those protections to additional categories of workers, including supervisors, managers, among others. OFCCP has made changes to the regulations implementing Executive Order 11246 in Section 41 CFR Part 60. In the definition section located in 41 CFR 60-1.3, definitions were added for compensation, compensation information, and essential job functions. In these sections 60-1.4, In the Equal Opportunity Clause, a new paragraph includes a non-discrimination provision mandated by the amended executive order. And finally, section 60-1.35 was added, which not only describes potential defenses for contractors, but also requires contractors to notify employees and job applicants of non-discrimination protections. The EEO clause includes a provision that prohibits covered federal contractors and federally assisted construction contractors and subcontractors from discharging or any manner discriminating against employees or applicants because they inquire about, disclose, or their compensation or compensation of others. Where can a contractor find the amended EEO clause? The clause is located in the language of Executive Order 11246, Section 202. It is also available in Electronic Code of Federal Regulations. Link to these locations can be found in Executive Order 11246 and frequently asked questions landing page on OFCCP website. If a contractor already references the OFCCP EEO clause in its purchase orders or subcontractors, does that contractor now have to do anything else to do the EEO clause reference it previously used? No, not under amended executive order. The contractor can continue to reference the EEO clause and use it entirely. So, sorry, I'm thirsty. In the section, now we're going to talk about, I think we can skip this part because we only have a little amount of time. Definitions. OFCCP enforcements include protecting workers for compensation discrimination based on their protected categories. Enforcing this protection involves factual investigations, data, and legal analysis, which allows OFCCP to identify remedies and any unlawful discrimination. To ensure consistency in implementing all of OFCCP's protection, the agency defines the terms compensation, compensation information, and essential job functions, which are terms involved in uncovering compensation discrimination. The regulation defines compensation as payments made or offered as for employment, including but not limited to salary, wages, overtime, shift differential, bonuses, commissions, vacations, holiday pay, allowances, insurance, and other benefits, stock options, awards, profit sharing, and retirement. It should be noted that the list of compensation types was not meant to be exclusive. I think we can get that. Skip these. Okay. So let's go into the scenario base in order to better understand what is accepted and not accepted in discussing your pay. In addition to exceptions provided for in the regulatory text, there are many other exceptions in the essential job function defense that arise. For instance, if an employee with access to compensation information as part of their essential functions discovers a potential pay disparity involving other employees, they may discuss it with the contractor management official while using the contractor internal complaint process. Additionally, defense only applies when an employee is disclosing compensation information about others they can learn through their essential functions. So an employee can always discuss their own pay information about pay that they learn from outside their essential functions. So what that is basically an employee who has part of their essential functions can look at other people's pay analysis, and if they see there's pay disparities, they can only discuss that with essential like management or internal structures. They can't go out and disclose it with their coworkers. However, if it's not part of your essential functions, then you can talk freely among each other about your pay, and that way there's no violation of the essential function clause. Now, scenario one, the essential function defense scenario. Contractors can't disclose. You know what? This is the slide deck got kind of jumbled up on for me, so I apologize. Basically, contractors cannot discriminate against individuals who openly discuss their pay with their coworkers in the break rooms or in the other scenarios based upon if it's not their essential functions. If it is your essential functions, you cannot disclose that information that you obtain through your duties. And so that's basically the scenario for the covering of the pay secrecy dealing with OFCCP. And I only have I'm trying to condense 50 slides into a short period of time. I think these are all the scenarios. I think that's pretty much all I have because the other scenarios won't cover the slide deck. So I'll turn it over to Stephen.
Thank you. And if you have any links other than what I've already posted in the chat, if you want to add any links to the chat, that would be greatly appreciated.
Thank you.
All right. Let me share my screen really quickly here. Okay, and is everyone able to see that okay? All right, perfect. Okay, so the Davis-Bacon Act, like I mentioned before, I work for the Wage and Hour Division. For those of you who may not be super familiar with us, we are the federal agency that enforces nearly a dozen different federal labor laws, including the Davis-Bacon and related acts. Out of our office, we cover the entire state of Alaska, as well as almost the entire state of Washington. The only two counties we don't cover out of Seattle are going to be Clark County and Spokane County. Both of those counties are handled by our Portland office and then our Boise field office. And real quick, this is just a very standard disclaimer we show to everybody anytime we give any sort of presentation. It just says that this is being given as a public service for educational purposes. Nothing I say today carries any weight of legal opinion or anything like that. I think we'll have a couple of minutes for questions at the end, so I'm definitely happy to answer those. If there's not enough time for questions, I'm definitely happy to make myself available beyond today as well. So like I mentioned before, my agency, we enforce a bunch of different federal labor laws that pertain to pay and hours worked. So that includes the Fair Labor Standards Act, the Migrant and Seasonal Agricultural Worker Protection Act, the Employee Polygraph Protection Act, the Family and Medical Leave Act, the FMLA. We also handle wage garnishment provisions, and then a number of different employment standards related to guest worker visa programs. That would be things like the H-1B, the H-2B, and the H-2A visa programs. And then, of course, the Davis-Bacon and related acts, as well as the Service Contract Act. So to give you just a really quick history of Davis-Bacon, it was passed in 1931. It was the first federal law that provided a minimum wage standard for non-government workers. In 1934, they then passed the Copeland Act, which added the statutory requirement that contractors submit certified payrolls, and it made it a felony for workers to kick back any portions of their wages. Then in 1962, Congress passed what's called the Contract Work Hours and Safety Standards Act. We call it QASA for short. And basically it required and codified the need for overtime payments for workers who are working on a covered Davis-Bacon contract, who work over 40 hours in a single work week as laborers or mechanics. And it's overtime like we would commonly understand. It's time and a half for all hours worked over 40 in a single work week. At first, Davis-Bacon didn't really address the issue of fringe benefits. Those are things like vacation pay, sick leave, health insurance, retirement benefits. So it began requiring that, or it began requiring the cash equivalent of those things to be paid out. The prevailing wage rate and the fringe benefit rate, they're always going to be listed in the wage determination that's incorporated into the contract. So I mentioned really quickly, the concept of coverage, if there's a project that's covered under the Davis-Bacon Act. So for our enforcement purposes, for something to be covered under the DBRA, the project contract needs to be in excess of $2,000 for the construction, alteration, or repair. $2,000, it's pretty easy to meet these days. In the 12 years I've worked for the agency, I don't know that I've seen one less than $2,000 that's federally funded. For the overtime provisions for Quasi, the contract needs to be in excess of $100,000 for the overtime provisions to kick in. So the Davis-Bacon prevailing wage, it is the combination of the basic hourly rate and any fringe benefit that's listed on the Davis-Bacon wage determination. The contractor's obligation to pay at least the prevailing wage that's listed in that wage determination, it's met by paying those laborers and mechanics that applicable wage rate and or combination of cash wages and employer provided fringe benefits for the job classifications that they're working in. So workers, they can't be paid a rate lower than the rate that's listed in the wage determination for any work that they're performing, just because they may not have any experience in that particular job category, or maybe if they're lacking some kind of license. If they're performing that work, they still need to be paid the appropriate prevailing wage rate for that work. So if you have like a carpenter who is spending some time that he's cleaning up at the job site, that person still needs to be paid as a carpenter, even for that time that they're cleaning versus being paid as a laborer. So there is an exception sometimes for apprentices who may be paid less than the prevailing wage rate for the work that they're performing, as long as there's certain requirements that are met. So those requirements, there's, I think, 3 of them. So the first one is that individual, they need to be registered in a bona fide apprenticeship program that is registered with the Employment Training Administration's Office of Apprenticeship, that's within the U.S. Department of Labor, or they need to be in a program with a state apprenticeship agency that's recognized by DOL's Office of Apprenticeship. That's the first requirement. The second one is that they need to be employed in compliance with the program requirements, including being paid the percentage of the hourly rate that's required by that apprenticeship program and the fringe benefits that are specified in that approved program, as well as being employed within the allowable ratio that's also specified in the apprenticeship program. So that's the second requirement. The third one is they need to be performing work within the scope of the classification covered by that apprenticeship program. So what hourly rate do apprentices need to be paid? So again, every apprentice needs to be paid not less than the rate that's specified in their registered program for their level of progress. It's usually expressed as some kind of percentage of the journeyman hourly rate that is specified in that wage determination that's incorporated in the contract that they're working on. And apprenticeship programs, typically, they specify the percentage of that hourly rate that's required for each level of progression that they're going through within that program. So it could be necessary to convert that dollar amount to a percentage if it's not explicitly specified for compliance purposes, to really determine the minimum hourly wage for an apprentice. The percentage specified in that program for their level of progress, again, is always going to be applied to that journeyman level hourly wage rate that's listed in the wage determination. And a second ago, I did mention the ratio issue, right? So a contractor is limited in the number of apprentices that they're permitted to have on a covered project. And it's based on the allowable ratio of apprentices to journey workers that's specified in the approved apprenticeship program. So compliance with the ratio requirements is determined on a daily basis. It's not weekly. It's not over the course of the project as a whole. It's always determined on a day-to-day basis. So any worker listed on a payroll at an apprentice wage rate, who's not registered in an approved program, or who is otherwise not employed in compliance with the hourly rate or the fringe benefit and ratio requirements specified in that approved program, they then need to be paid the applicable wage rate, the prevailing wage rate that's in the wage determination for the classification of work they're actually performing. So, it means that they need to be paid the full prevailing wage rate if they're not employed in compliance with those requirements. One quick thing to note is that employment of a properly registered apprentice by more than one employer, it doesn't affect the status of that apprentice. The transfer of apprentices from one employer to another to provide different kinds of work and training, it's generally accepted in the construction industry as a common practice. So again, that employment of that apprentice by more than one employer, it doesn't affect their status as an apprentice. So those were just some of the really key principles of Davis-Bacon that I wanted to make sure we had time to touch on. Again, I'm definitely happy to answer any questions if there's any others, but I also wanted a chance to go over our investigative process, just so that you all have an understanding of what that looks like. On the screen, you can see this chart. It really just kind of cleanly breaks down the investigative process into 8 different steps. It starts with what our preliminary steps are, ends with our case conclusion and some of the back-end report writing that we do behind the scenes. But in the preliminary steps of the investigation, this is kind of what we look for anytime we start an investigation of a Davis-Bacon covered contract. We want to know that the labor standard clauses are in the contract. We want to know that there's the wage determination that is properly incorporated into the contract. We usually obtain certified payrolls from either the contracting agency, or we may start requesting it directly from the employer themselves. And then we start getting identifying information from the employer. Generally speaking, we are always going to contact the contracting agency, the federal agency that holds the contract with the contractors, and let them know that we are about to conduct an investigation of someone they're contracting. They're then kept in the loop throughout the entire process. We hold what's called an initial conference with the contractor. So really that's a meeting with what we call a responsible official of the contractor. It's someone that they will designate to represent them, or it could be the owner of the company themselves. Anytime we investigate a subcontractor, the prime contractor is also notified. And an initial conference is, again, appropriate to inform that contractor of the investigation. We let them know what the scope of the investigation is. We let them know what records that we are going to examine. And we conduct worker interviews at the physical job site. We also conduct a physical inspection of the job site. We take a tour. We want to see and hear everything. We want to know what it is the workers are actually working on. We want to witness some of the projects that they're working on, some of the tools that they're using. And then again, we get all the identifying information on the employer. Any of their trade names, their full address, names of the owners, if they have any corporate officers. We want their job titles. We want to know how many employees they have, their tax ID number. If there are any subcontractors on the contract, we request all the similar information from them as well. So examining the contractor's certified payroll, we're looking for accuracy, completeness, and a true representation of the facts. Our review, it should start with the current or most recent payroll, as well as those that we may select for certain periods of time. We may choose to get representative samples, depending on the scope of our investigation of different payrolls, or we may request a full 3 years of time and payroll records. We are going to look at the certified payroll. We may look at basic time cards, any logbooks, time sheets, or other work personnel records. Again, either from a representative number of workers or from everyone that has worked for that company in the previous 3 years. If there are apprentices, we also gather that information because, of course, like I mentioned, we want to see that they're being employed in compliance with apprenticeship law. We need information on their program. We'll check to make sure it's certified and recognized by the Office of Apprenticeship or a state agency, and that the ratio of apprentices to journey workers on the project is also in compliance. So I mentioned some worker interviews. Worker interviews, again, we conduct those on site with current employees who are there working. We also may do follow-up interviews by phone or additional meetings, and then we may choose to interview former workers as well. It's an essential part of the investigation, and as you can see on the slide, it is confidential. The employer, the owner, managers, they are not allowed to sit in on these interviews. And we just record all the information there. We make sure we have, we're recording the place, date of the interview, name and address, contact information for the worker, what it is, and then we get a better idea of what it is that they're doing. We ask them questions concerning the job duties they're engaged in, the tools that they're using, and then we check to see if there are any potential violations. So again, potential violations could be the improper classification of workers, right? If you have someone who is working as a carpenter, but they're classified as a laborer, that might be an issue. If you have someone who is doing window work, they're a glazier, but they're being paid as a carpenter, that is another issue, right? So if they are misclassified, those are violations we would cite. We want to ensure that workers are being paid appropriately for the work they're doing at the correct prevailing wage rates that are listed in that wage determination. And part of how we determine that is by conducting those interviews and gathering all those records and reviewing them as part of our investigation. So Davis-Bacon, it really involves, again, the application of specific minimum wage standards, those prevailing wages, for every laborer and mechanic that's on the site of work, and that they're performing on the contract that is listed at the appropriate prevailing wage rates and fringe benefit amount. Again, we look at everything. There are record keeping requirements, there are posting requirements. We want to ensure that certified payroll is turned in weekly, and we do check those certified payrolls. And then at the end of the investigation, we hold a final conference. We invite the contracting officer. If it's an investigation of the sub, we may inform the prime contractor. And this is where we let everyone know what the findings are, if there are any violations. If there are back wages due, that is where we assess them and ask the employer to come into compliance and to make that restitution for the workers. If there is a subcontractor we are investigating and they are refusing to resolve the issues, then we may hold the prime contractor liable for those back wages then, since they are the prime on that contract. And then I think this might be a good stopping point because I do know we want to make sure we have questions. So right there is just some online resources that you can check out for Davis-Bacon. There's some stuff on there. There's the resource book in particular in the middle of that slide. It's really great. It's a great resource. We have it publicly available. It really walks you through all of the Davis-Bacon provisions, and it does it in a really easily digestible way. So definitely encourage you to take a look at that one in particular. But yeah, other than that, I think that's a great stopping point, and happy to take some questions if there are any.
Thank you, Stephen, so much for an excellent presentation. Do we have any questions from attendees? You can either write them in the chat. You're welcome to turn on your screen if you'd like and unmute at this time.
Stephen, I got a quick question about Davis-Bacon. So with the new rules since last year, if there's a wage violation for Davis-Bacon wages, is there now, in addition to having to pay the back wages, is there a penalty under the new Davis-Bacon rules?
I don't believe there are penalties in the new rules. I'll have to take another look. I know that if we do find an egregious issue with a contractor, debarment is always a possibility for 3 years from participating in government contracts.
Okay.
But I would have to look again at the new rules and see if any monetary penalties are on the table.
Okay, because it's kind of like on the same vein of like a FLSA violation. If there's $20,000 of back wages, but then the LDs kick in, now it's $40,000. I didn't know if there was something similar in all the new rules that have come out regarding the Davis-Bacon Act.
Right, right. There aren't LDs under Davis-Bacon. There are under Quasi, but I don't believe it is a dollar for dollar LD assessment under Quasi. But again, I'd have to double check.
Awesome. Thank you.
Mhm.
Thank you so much, Steve, for the question. Are there any other questions for Stephen or for Edward? All right, I'm not seeing any. And so the interest of sake of everyone's time, Stephen, thank you for the excellent presentation. Edward, thank you as always as being part of this process. This video will be available on YouTube on the Construction COE channel within the next week. And I wish you all a wonderful afternoon. Thank you again so much, Stephen, for the great information.
Yeah, thanks for having me. I appreciate it.